Hello, everyone. Welcome to our webinar, National Instrument 51101 for Officers and Directors. I'm Craig Burns, Manager of the ASC's Energy Group. I will be jointly presenting with Michelle Turner, one of the Energy Group's Senior Valuation Engineers. The webinar's purpose is to review certain information and responsibilities of importance to officers and directors of reporting issuers engaged in oil and gas activities for National Instrument 51101. Officers, directors, and their professional advisors are expected to benefit. The basics won't be covered here. If interested, please see our Beginner's Guide to NI 51101 webinar posted at asc.ca. With respect to the agenda, we'll have a brief introduction. This will be followed by applicability of NI 51101, followed by the annual filing requirements per Part 2 of NI 51101. Then key responsibilities per Part 3 and material changes per Part 6 of NI 51101. Introduction. The ASC administers Alberta securities laws. It's entrusted to foster a fair and efficient capital market and protect investors. The ASC is a member of the Canadian Securities Administrators, or the CSA, whose role is to improve, coordinate, and harmonize regulation. The ASC is the CSA's lead oil and gas regulator. The Energy Group within the Corporate Finance Division of the ASC has an all things energy focus. We cover such things as oil and gas, helium and hydrogen, lithium from brines, carbon management, electrical generation, renewable hydrocarbons, etc. What is National Instrument 51101? Well, it's the standards of disclosure for oil and gas activities, or NI 51101. It applies to reporting issuers engaged in oil and gas activities. We will define that term in the next section. It addresses general standards and specific annual disclosure requirements. Its technical standard is the Canadian Oil and Gas Evaluation Handbook. It's part of a comprehensive framework that applies to all reporting issuers. Some other important materials point you to include the companion policy 51101 CP, Standards of Disclosure for Oil and Gas Activities. This is the CSA's views on 51101 and how it applies. Also, CSA Staff Notice 51324, revised glossary to NI 51101. You'll find many of the terms used in this webinar defined in that staff notice. Also, a subset of the terms that you will encounter today are also defined in section 1.1 of 51101. And lastly, the Energy Matters reports that the ASC publishes annually. You will find those at asc.ca. In addition, I'll just point you to, we have historically created the Oil and Gas Review Report, and so you will find many years of those archived at asc.ca as well. Next up, applicability of NI 51101. NI 51101 applies to reporting issuers engaged directly or indirectly in oil and gas activities. We will define this in the next slide. Oil and gas activities is broadly defined. It applies to material information. And one other important thing I'd like to add here is that issuers are considered engaged in oil and gas activities if a document that incorporates prospectus requirements is filed with the Securities Regulatory Authority or the SRA. Now, this topic is not often well understood. It can result in misfilings and other disclosure issues. Small reporting issuers and reporting issuers with multiple business interests most frequently run into issues with applicability of 51101. Next thing we're going to do is we're going to move through a series of definitions that are key to understanding the subject of oil and gas activities. That first definition is actually the term oil and gas activities. Oil and gas activities includes the following: searching for a product type in its natural location, acquiring property rights or property for the purpose of exploring for or removing product types from their natural locations, any activity necessary to remove product types from their natural locations, producing or manufacturing of synthetic crude oil or synthetic gas. Mention here that italicized terms are defined in Staff Notice 51324 and in section 1.1 of 51101. Most of them are, not all of them. Underlying terms are defined in this section in particular. Oil and gas activities does not include any of the following. And this is the most important part: any activity that occurs after the first point of sale. So you saw that we had product types underlined in the previous slide. What does product type mean? Well, it means any of the following: bitumen, coal bed methane, conventional natural gas, heavy crude oil, shale gas, tight oil, etc. One thing you'll notice, it does not include helium. Next up is the term property. This includes fee ownership or a lease, concession, agreement, permit, license, or other interest representing the right to extract oil or gas, subject to such terms as may be imposed by the conveyance of that interest. It also includes royalty interests. This is an extremely important one. A lot of issuers are not aware that royalty interest or an interest in a royalty interest will have them considered engaged in oil and gas activities. It also applies to those with an agreement with a foreign government or authority under which a reporting issuer participates in the operation of properties or otherwise serves as a producer of the underlying reserves. So, as I mentioned just a moment ago, if you have a royalty interest, you'd be in an oil and gas property, you'd be considered engaged in oil and gas activities. Naturally, as an extension of that, if you only have royalty interests, you would certainly be engaged in oil and gas activities. The term first point of sale was used. Well, this means the first point after initial production at which there is a transfer of ownership of a product type. And lastly, in this section, the term material. For the purposes of NI 51-101, information is material in respect of a reporting issuer if it will be likely to influence a decision by a reasonable investor to buy, hold, or sell a security of the reporting issuer. Now, this term, as we use it in 51-101, differs from the definitions of material change and material fact as are used in securities legislation. Note that I said previously that 51-101 only applies to material information. While you may be engaged in oil and gas activities and therefore subject to 51-101, what you are actually required to disclose specifically will be limited to material information. Now, another thing that I would just add here, that it's very, very important to look at all the terms used in the definition of oil and gas activities collectively when you're trying to understand the applicability of 51-101. If you just look at the term oil and gas activities and its definition, you may be led astray. You may consider yourself to not be engaged in oil and gas activities, as you've seen as you look through the definitions that are two terms that are actually included in the definition of oil and gas activities. It gives you a much more thorough it can give you a much more thorough perspective on that term.
So Craig has gone over who National Instrument 51-101 applies to. I'm going to briefly discuss what the annual filing requirements are for those reporting issuers engaged in oil and gas activities, as this may be helpful to discuss this information before we talk about the specific responsibilities of officers and directors. So, as Craig mentioned, Part 2 of National Instrument 51-101 requires issuers engaged in oil and gas activities, where that information is material, to file annually with the Securities Regulatory Authority, in most cases, 3 main forms. So first is the F1. This is the Statement of Reserves data and other oil and gas information, which is provided as at the last day of the issuer's most recent financial year. So, for example, for a December 31 financial year, the effective date of all of the information being provided in the F1 would also be as at December 31 of that same year. So the F1 includes requirements regarding the disclosure of reserves, volumes, and values, forecast pricing, the future development of reserves, things like production history, production estimates, and information about the issuer's oil and gas properties, and other related information. It's important to note that to the extent that any item or component specified in the F1 does not apply to the issuer or it's not material, it is not required to be disclosed in the form. So for example, an issuer may determine that they had no reserves, but they're still engaged in oil and gas activities, and they therefore may be subject to the requirements of the F1, for example, under Part 1, relevant dates, and Part 6, other oil and gas information. That said, even if they had no reserves to be disclosed in the F1, they are still required to file the F1. Historically, we have seen issues with a reporting issuer engaged in oil and gas activities, not completing their filings as required because they don't think they need to, because, for example, they don't have reserves. But like I mentioned, the F1 is still required. I'm not going to go into any further details around the F1 requirements. For more information, there is an ASC, on the ASC website, there is a recording for 51-101 for beginners webinar, which goes into much further details. Okay, so as I mentioned, an issuer engaged in oil and gas activities may or may not have reserves. So it is the issuer, their management, the board of directors, who are all responsible for reviewing the issuer's oil and gas activities and determining whether the issuer had reserves as at the last day of that financial year. And it's their responsibility to determine whether an independent qualified reserves evaluator or auditor should be retained. So if the issuer determined that they had reserves or they choose to disclose resources other than reserves in their F1, and they retain that IQ or ERA, they must file a report in accordance with the F2. This is the report of the independent qualified reserves evaluator or auditor. It's important to note here that the F2 is executed by the individual IQREs or A's who completed the work. So we would expect those individual signatures, not just the company or evaluation firm's name, and it's not executed by the issuer. That said, the issuer is responsible for the filing of the F2. And in the case, like I mentioned, where the issuer determined that it had no reserves, or they don't disclose resources other than reserves, they don't retain that IQ or ERA, they would not be required to file the F2. Okay, so the third main form required under 51-101 related to the annual filing requirements is the F3. This is the report of management and directors on oil and gas disclosure. So regardless of whether the issuer had reserves or disclosed resources other than reserves in their F1, the F3 applies. The F3 is critical. It confirms the responsibilities of management and the board of directors with respect to those annual filing requirements. So this confirmation occurs when the F3 is executed by two officers, one being the chief executive officer of the company, and then another officer of the company, and then on behalf of the board by any two other directors. So it's key to note here that these are four separate individuals signing the F3. Another key point here, I'll go into more details on the later slides on this topic as well. But the execution of the F3 confirms the review and approval of the content and the filing of the F1 and the F3 itself, and confirms the review and approval of the filing of the F2. Okay, so I did mention those three main forms relating to the annual filing requirements. There is one more form to mention. This is the F4. So if an issuer includes the F1, F2, and F3 in their AIF or annual information form, they must also file the F4, indicating that they have done so. We do see that the F4 is often missed, so it's important to ensure that if it's required to be filed, you need to file it. As well, we sometimes see issuers filing both the separate forms and then also including the forms in their AIF. The issuer is required to do one of these things, not both. Okay, so now we generally know what the annual filing requirements are. I'm going to discuss the key responsibilities of the issuer, management, and their board of directors, and how it relates to those annual filing requirements. Okay, so part 3 of 51-101 outlines the responsibilities of the reporting issuer and its directors. There are certain responsibilities that are applicable to the reporting issuer and certain responsibilities pertaining to the directors and other requirements that are similar and overlap between the two. Okay, so first, the issuer. So if it determined that it had reserves or it chooses to disclose resources other than reserves, as at the last date of the most recent financial year, the reporting issuer must appoint one or more independent qualified reserves evaluator or auditor. It also must direct each of these independent evaluators or auditors to report to the board of directors on the reserves data, contingent resources data, or prospective resources data that will be contained in the F1. Key point here, this meeting between management, the directors, and the evaluators or auditors, this occurs prior to the issuer filing the F1. In addition to that, the issuer also must ensure that the IQREs or A's have all of the information necessary to complete their evaluation or audit as required. Okay, so I mentioned there are certain responsibilities of the issuer's board with some similarities and overlap with those responsibilities of management. For example, the board of directors must review with reasonable frequency the issuer's procedures for providing all of that necessary information to the IQREs or A's. And they also must review the issuer's procedures relating to the disclosure with respect to oil and gas activities. As well, the board must review the issuer's appointment of those IQREs or A's. And if there is a change, the board must understand why there is a change and understand whether there was any disputes between previous evaluators, auditors, and management. So one way to think about it is that Part 3 of 51-101 outlines some of the key steps in an issuer's process that are necessary for completing their annual filing requirements under 51-101. So for example, the issuer determines that they had reserves, or they're going to choose to disclose resources other than reserves. They then appoint their IQRE or A. They make sure that the evaluators or auditors have all the information necessary to complete their work. And then the board oversees that all of this happens as required. So the next step after all of this, and a very key responsibility of the board that takes place before the board approves the filing of the F1 and the F2, is that the board must meet with management and the IQREs or A's. So first, the board needs to determine if there were any restrictions that affected the evaluators or auditors' ability to report without reservation. And importantly, at this meeting, they must review the reserves data, contingent resources data, or the prospective resources data that will be contained in the F1, and they need to review the F2. So this is a key step. It involves management, the IQREs or A's, and the board of directors meeting and reviewing that material information, which will then be disclosed to the public. One way to think about it, it's kind of like the last line of defense, where any potential discrepancies, concerns, or issues should be caught if everyone is fulfilling their responsibilities and roles as required. So after this meeting, the board is then responsible for reviewing and approving the content in the filing of the F1. Like I mentioned, that'll contain the reserves data, contingent resources data, prospective resources data that was just reviewed with management and the IQREs or A's. Really important to note here, the board of directors is responsible for reviewing and approving all of the information contained in the F1. Not just, for example, the reserves data. There's a lot more disclosure requirements in the F1. The board is responsible for all of it. As well, the board is also responsible for reviewing and approving the filing of the F2. Again, this would have been reviewed at that meeting with management and the IQREs and A's as well. Finally, the board of directors is responsible for reviewing and approving the F3. Again, the F3, it has to be executed by the CEO, another officer of the company, or it is executed by those individuals who have the responsibilities normally associated with those positions, or those who act in a similar capacity. And then, like I said, any two other directors of the company. So if the board has reviewed and approved the content in the filing of the F3 as required, staff expect 4 individual signatures to be on the F3. In rare cases, a reporting issuer may only have 3 directors, one being the CEO, one being another officer, and then a third director. In that case, obviously, we would expect 3 signatures on the F3. We have noted that in recent years, we have seen either one or both of the directors' signatures missing from the F3. When this occurs, staff will likely contact the issuer to assess the circumstances regarding the F3 and determine if any further action is required. Like I said, it's important to note that we would flag an F3 with missing signatures as not meeting the requirements. Okay, so I have gone over the responsibilities pertaining to the board of directors. That said, there are certain responsibilities under 51-101 in many cases where it may be more appropriate that they're fulfilled by a smaller group who bring a particular experience or ability and an independent perspective. So under 3.5 of 51-101, it permits the board of directors to delegate certain responsibilities under 3.4, other than the responsibilities to approve the content and the filing of the forms to a board committee. So this is often referred to as a reserves committee. I'm not going to go over the specific bullets on the slide, but as you can note, a key requirement of the reserves committee is that the majority of its members must be independent. Okay, so if the board of directors does delegate certain responsibilities set out in section 3.4 to that reserves committee, the board must solicit the committee's recommendation as to whether to approve the F1 and the F2 and the F3. That said, it ultimately, it is still the board's responsibility, of course, after receiving the committee's recommendation, to approve the content and the filing of the F1 and the F3 and approve the filing of the F2. So like I said, the board is still ultimately responsible. Okay, so now I'm going to pass it back to Craig, and he's going to go over the topic of material changes.
Thank you, Michelle. Next up, material changes as they pertain to NI 51-101. Keep in mind that what we're going to discuss here applies to reporting issuers engaged in oil and gas activities. Now, this occurs within a broader framework of material change disclosure requirements. So, a reporting issuer is expected to discuss the reasonable expectation of how a material change would have impacted the reserves data and other information in the reporting issuer's most recent F1 had it occurred on or before its effective date at its most recent financial year end. It's expected that a reporting issuer will use whatever means necessary to explain the changes in their how that material changes affected their disclosure at their most recent financial year end, using either or both of qualitative and quantitative means. Could also include such things as a pro forma presentation. Lastly, we're going to discuss the Form 51-101 F5, notices ceasing to engage in oil and gas activities. So within 10 days of a reporting issuer determining that it has ceased to be engaged in oil and gas activities, it must file a notice with the Securities Regulatory Authority that's in accordance with the F5. Now, this is often missed by reporting issuers, generally small reporting issuers. This can result in some of these issuers being noted as being in default for misfilings because they haven't filed. If they do file, we note the issuer is not being engaged in oil and gas activities, and we will no longer be looking for their filings. So that concludes our webinar. Thank you, everybody, for attending. Next, I just want to note here that at the end of this slide deck, you will see our contact information. Please use that to reach out to us with any issues whatsoever involving energy. We'd be very happy to help you. Thank you very much.